Good morning to all of you. Welcome to Legal Matters by Sai Babu Sokara. In this video, we are discussing the constitutional issues regarding the doctrine of pleasure to be exhibited by the governor of a state and the relations of the governor with the council of ministers and whether the governor can refuse to administer oath to a minister. Why we are discussing all these things is Mr. Saji Cherian conundrum was continuing till yesterday in Kerala state. Of course, finally the governor agreed to give a date for the induction of Mr. Saji Cherian as a minister, or I can say it's a re-induction. So, without giving you the brief facts of the details, it will be waste if I continue the video, because unless you know the facts, it is very difficult to appreciate or understand the problem. On July 5th, 2022, Saji Cherian, an MLA from Chengannur Assembly Constituency of Kerala State. Of course, you know, he is a CPM activist. He openly criticized our Indian Constitution. So, in his words, he said in a public meeting, "We claim that our Constitution is the beautiful one." Yes, definitely, we have to agree. I can say our Constitution can loot the maximum number of people in the country. And it is something dictated by the British and written in verbatim by the Indian people in our Constitution. So this is the comment. That means the Constitution is there to loot the public. So it's a very serious comment. Lot of resentment has appeared. Ultimately, he was asked to resign from the post of the minister. He was the minister for fisheries, culture and urban development or something. He was having 3 portfolios: minister for fisheries, culture and youth affairs. Anyway, he has to resign. But there was resentment or inner criticism. So previously, Shri E.M.S. Namboodirpad, he is no more. So he commented against the judiciary, highest, particularly the Supreme Court judiciary regarding that land reforms. So the judiciary, because the lawyers are from the affluent families, the judges are from affluent families, they are supporting the so-called Article 19(1)G or F, that is land rights of the landowner. So the coolies are remaining as coolies. It was taken as contempt. ఆ కాలంలో మీకు contempt of courts వచ్చినప్పుడు చెప్తాను. EMS Nambur కేసు. And he stood by it. He was given 1 month jail also. అలాగే ఈయన కూడా మొత్తానికి కేరళ స్టేట్ కదా, he commented, but anyway he lost his post. Once again he has to be inducted. This is the background or scenario. So now coming to the Arif Khan, he may be Kerala Governor Shri Arif Muhammad Khan. Actually, there is a tussle between him regarding the postings of the university chancellors. Here the matter has come to the Supreme Court, and somehow some vice chancellor has been removed by him also. So this thing is going on. Anyway, we can understand that a tussle is going on between the governor and the government or chief minister, Mr. Pinarayi Vijayan. While things stood like that, another incident has come. So the government of Pinarayi Vijayan, they wanted to re-induct Mr. Saji Cherian, but when the comment came, then Arif Muhammad Khan, on that itself he stated that, "Friends, I can remove the minister basing on 164, that is doctrine of pleasure." So when these people wanted to re-induct him, so definitely Governor Arif Khan kept everybody guessing whether he will give the date for re-induction or not. So that is the scenario. Of course, yesterday he has agreed and he has given the date, and that Saji Cherian, he will be inducted. Right. So already universities problem, they had lit the fire. Anyway, doctor, Article 163. This is, please remember, Council of Ministers to aid and advise the governor. Yesterday in the Kaushal Kishore case, I told you that the Prime Minister of the Chief Minister, no doubt they have only general supervision. They do not have any disciplinary authority on a minister. Suppose if a minister makes some derogatory statements like this, straight away they cannot suspend him. He will be asked to resign. Same is the case here. So, in that case also told, they are, please remember, the Council of Ministers, they are collectively responsible for any decision taken but not individually. Here, so Article 163 says, Council of Ministers to aid and advise the governor. Of course, you know, CM as the head, and CM will be appointed by the governor, and on his advice, the ministers will be inducted by him or the right. As regards 164, all ministers shall hold the office during the pleasure of the governor. So please remember. So using the powers under Article 164, the governor Sheikh Khan threatened to drop ministers and also who insulted him in public. This is another issue. So anyway, now the point is whether he will give permission or not. Suppose he has given already permission. In case, if he refuses to administer the oath, then what will happen? He has to take an oath, he has to be re-inducted. Unless he takes oath, he cannot be inducted as a minister. So this is what is stated in our so-called Schedule 3. Schedule 3, you may be knowing, it contains all the forms of oaths, affirmations, oaths and secrecy, all these things will be there under Schedule 3. He has to comply with Schedule 3. But here, suppose if the governor does not give the date, if the governor refuses to give the date, if the governor gives no reply, then what to happen? So a classic case occurred in the year 1978, if I am correct. No, 1978, yes. So please remember, according to Article 164, Clause 3, governor shall administer the oath and secrecy. Right? Already the Schedule 3 contains the forms of the so-called oath or affirmation. Right? In April 1978, Vasant Pai, actually he was a senior advocate. He was elected as MLC in Tamil Nadu from the graduates constituency. Right? So actually, as per Article 188, the MLC should be administered the oath. But please remember, he did not want to take the oath before the pro tem speaker with whom he has got some differences. Therefore, he approached the governor, I think say Prakasha or somebody, whatever, I don't know his name. So he approached the governor and requested to take oath, to administer oath to him. Instead of the pro tem speaker, he wanted to take a oath before the governor, but the governor did not respond. No answer. Ultimately, he is a liar. So he sent a telegram, but there is no reply. Ultimately, what he has done, Pai has sent 2 oaths in Schedule 3, that is official oath of secrecy and oath of affirmation. Both these things are duly signed by him. And he has sent to the governor. Then he filed a writ petition before the Honorable High Court of Madras seeking direction that it should be presumed that he has taken oath. Yes, court allowed the same in June 1978. So please remember, if the governor does not administer the oath, you can send it in writing, and it has been appreciated or okayed by the Honorable High Court of Madras also. This is one simple incident. So why I am making this is, actually this is a news item given by Sri K. Chandru. You may be knowing, Chandru is very famous for our JV film. Yesterday I studied it in the Hindu. Therefore, out of academic interest, I have made this video. It will be definitely useful for you. Please read or see the video once or twice and enrich your legal knowledge. With this, I am concluding. Thank you very much.